Okay, welcome to today's presentation of antitrust developments in 2024. I am Lisa Josie Fales. I am the longtime chair of Venable's Antitrust Practice Group. I'm joined today by my good friend and partner, Danielle Foley, who's been litigating antitrust cases for over 25 years, and my partner, Bill Vegan, who joined us from the DOJ's Antitrust Division, where he was doing criminal antitrust enforcement. So today we'll discuss developments in enforcement actions by the DOJ, the FTC, state attorneys general, and the private plaintiffs bar. We will cover information exchanges, healthcare issues, labor issues, and dramatic changes to the pre-merger notification process and the merger guidelines, and more. So now a quick note from our sponsors. Venable is proud to offer CLE credit for this program in New York, Illinois, California, and currently pending credit in Florida. Please reach out to our events team if seeking Virginia or out-of-state credits. So let's get going. So who enforces the antitrust laws? Of course, the Federal Trade Commission, the U.S. Department of Justice, and the state attorneys general. You can also be facing litigation from the private plaintiffs bar, who bring large multi-district class action cases. You may well be battling these cases simultaneously on all of the above fronts. These cases can last years and could cost millions to defend. They are drained not only on a company's financial resources, but on executives' time and patience. They can also be accompanied by negative press. The antitrust penalties are nothing to sneeze at. Companies can be fined up to $100 million per violation, and they are, as you'll hear from Danielle in just a moment. Injunctive relief can be awarded against companies, prohibiting them from engaging in certain conduct. Individuals are also liable for violations of the antitrust laws, and the penalties are severe. A violation of the Sherman Act is a felony. Individuals can be jailed for up to 10 years or fined up to $1 million per violation, or both. And they are, as you will hear from Danielle. So Danielle, turn it over to you to talk about recent fines, settlements, and verdicts.
Thank you, Lisa, and thank you to all of you for joining us today. So we show you these recent fines, settlements, and verdicts not to scare you, although some of the numbers can be scary, but to highlight that government enforcers and private plaintiffs attorneys are actively pursuing antitrust cases in a variety of areas. There can be significant financial consequences if you are found to violate the antitrust laws. For example, in recent years, the civil penalties, as well as private settlements, have been in the tens, if not hundreds of millions of dollars ranges. In addition, while antitrust plaintiffs are not always successful when they bring their cases to trial, when they are, damages can be significant, as illustrated by the National Association of Realtors case, which was earlier in 2023. There, the plaintiffs won a treble damages verdict of $5.3 billion. So this is in addition to these costs, as Lisa mentioned, you will have costs of discovery and defending against an antitrust case, as well as business interruption costs and potential harm to the company's reputation, as well as individuals' reputation. The DOJ has continued to pursue criminal antitrust cases, not just against companies, but also against individuals. These cases can and have resulted in jail sentences, probation, and large fines when the DOJ has been successful. And to be clear, the DOJ is not deterred by a tough case. As exemplified by the broiler chicken case that's listed here, the DOJ tried that case 3 separate times. The first 2 trials resulted in hung juries, but the DOJ was not deterred, and it pursued a 3rd trial against some of the individual executives from those companies for a 3rd time, resulting in a full acquittal. So even when the defendant prevails, it can be a significant cost, time, and expense to battle against the case. Now I'm going to pass it to Bill, who's going to talk to us about new developments in the areas of enforcement regarding information exchanges and algorithms.
Thank you, Danielle, and good afternoon, everybody. I'll start first on information exchanges. Participation in an industry survey or benchmarking service has generally been permissible under a rule of reason analysis, provided that the exchange has a legitimate business purpose. In other words, under the rule of reason, the pro-competitive effects of the information exchange would be weighed against the anti-competitive effects to determine, on balance, whether the exchange is pro-competitive. For example, the exchange could enable a company to determine whether its price is competitive and lead to lower prices. This is oftentimes a complex balancing test involving economic evidence and expert opinion. However, information exchanges were never permissible if they were being used, for example, to effectuate a price fixing scheme. That would be viewed as per se illegal, meaning the exchange was used to facilitate a per se violation of the Sherman Act that would be illegal as a matter of law, regardless of the competitive effects. Now, when it came to information exchanges, for a long time, the DOJ and FTC had joint guidance that contained a safe harbor for information sharing if it was managed by a third party, the information was more than 3 months old, and there were at least 5 participants, and no single participant contributed more than 25% of the weight of the information shared, and the information was aggregated so that no one could discern whose data was whose. The DOJ and FTC withdrew this safe harbor provision in 2023 and have no plans to replace it. They noted they would examine any information sharing activities on a case-by-case basis moving forward. They will examine those types of cases using the same familiar antitrust framework discussed above, weighing the pro-competitive effects against the anti-competitive effects under the rule of reason, assuming there is no allegation of price fixing. Now, none of this means that information sharing that still follows the withdrawn guidance is problematic. However, the withdrawal of the guidance highlights the fact that the DOJ and FTC are more leery of information sharing, and the antitrust risk has now increased. That view has been borne out in 2 recent matters filed by the Department of Justice. First, in the United States versus Agristats, filed in September of 2023, the department noted that the lawsuit marks the latest action by the Antitrust Division to combat unlawful information exchanges. The complaint there alleges that Agristats violated Section 1 of the Sherman Act by collecting, integrating, and distributing competitively sensitive information related to price, cost, and output among competing meat processors. A motion to dismiss was filed by Agristats in this case in January of this year, and the DOJ filed their opposition last week. The motion remains pending. Second, in United States versus Cargill, the DOJ in July of 2022 filed a civil antitrust lawsuit against the data consulting firm and its president, as well as 3 poultry processors, to end a long-running conspiracy to exchange information about wages and benefits for poultry processing plant workers and collaborate with their competitors on compensation decisions in violation of the Sherman Act. These matters resolved by consent decrees with each defendant. So, given the agency's increased focus on information exchanges and without the safe harbor provision, where does that leave us? Well, as discussed, information exchanges are inherently riskier than before, and antitrust counsel should be consulted regarding any existing or contemplated information exchanges. Additional antitrust scrutiny needs to be applied to all initiatives involving any kind of information exchange with competitors. Information exchanges remain generally subject to the rule of reason, and thus the same general principles still apply. There must be a legitimate business justification for the exchange. For example, it helps create efficiencies to lower price or improve quality. The information exchange should be managed, aggregated, and distributed by a third party, and older data should be used rather than current or forward-looking data. The DOJ has recently focused on the use of pricing algorithms as per se antitrust violations. In other words, DOJ has challenged the use of pricing algorithms by alleging they are effectuating a price-fixing scheme. The Principal Deputy Assistant Attorney General for the Antitrust Division noted last year, where competitors adopt the same pricing algorithms, our concern is only heightened. That concern was reflected in DOJ's recent statement of interest in the In Re RealPage litigation, where it wrote, whether firms effectuate a price-fixing scheme through a software algorithm or through human-to-human interaction should be of no legal significance. Automating an anti-competitive scheme does not make it less anti-competitive. And it further noted its view that algorithmic price fixing must be subject to the same condemnation as other price fixing schemes. And although algorithms and AI have been a topic of recent interest in multiple industries, DOJ actually secured a guilty plea in 2019 based on allegations involving pricing algorithms. In the Aston case, DOJ alleged that the defendant and his co-conspirators discussed the prices of certain posters sold in the United States through Amazon Marketplace and agreed to fix, increase, maintain, and stabilize the price of those posters. DOJ alleged that in order to implement those agreements, the defendant and his co-conspirators agreed to adopt specific pricing algorithms for the sale of the posters with the goal of coordinating changes to their respective prices. Danielle?
Thanks, Bill. Now we're going to talk about some areas in antitrust enforcement that we expect will be coming up in 2024 regarding healthcare and the pricing of pharmaceutical drug products. Now, the Biden administration has taken a whole of government approach to antitrust issues in a whole host of kitchen table issues: food, drugs, healthcare, you name it, it's broad. And in the end of 2023, the administration announced initiatives to attempt to lower healthcare costs and prescription drug costs by promoting competition. And the FTC took up 2 initiatives in 2023 that go to these issues that we'd like to discuss with you. The first is the FTC's targeting of alleged misuse of the patent system by improperly listing Orange Book patents. And second is the FTC targeting alleged anti-competitive roll-ups or serial acquisitions in the healthcare space. Now, in terms of the Orange Book listings, it's important to keep in mind that the FTC has a long history of making an enforcement priority to challenge conduct that it alleges delays the availability of generic pharmaceutical drug products. In this way, the FTC has been pushing the boundaries of the law that comes at the intersection of the antitrust laws, the patent laws, and the FDA's regulatory scheme under the Hatch-Waxman Act. Many of you will remember that in the early days, the FTC took the position that any brand generic patent settlement where there was consideration flowing from the brand to the generic should be viewed as presumptively unlawful under the antitrust laws. Nearly 10 years ago, the Supreme Court rejected that view in the landmark decision FTC v. Activists and ruled that those settlement agreements, like most other agreements under the antitrust laws, should be treated under the rule of reason, where we balance the anti-competitive effects versus the pro-competitive benefits of the settlement. So with that perspective, the latest FTC policy regarding listing of patents in the Orange Book is really an extension of the FTC's long enforcement priority in this area. So what did the FTC say? In September 2023, the FTC announced it would investigate and prosecute alleged wrongful listing of patents in the Orange Book as unfair methods of competition. The FTC also said that it may scrutinize such listings and a company's alleged history of improper listings during merger reviews. So what does this mean? Well, to understand what it means, you have to put in context of what the Orange Book is. And in the pharmaceutical space, what happens when a new drug applicant files an application with the FDA, it must identify patents that cover the drug, and those patents get listed in the Orange Book. What does that do? It alerts potential generic companies to the existence of the patents. And it's a first step in a generic company trying to bring a product to market and challenge a brand's patents. If a generic attests that a product it is filing an application for does not infringe one of the Orange Book patents in its application, that is a technical act of infringement. And when the brand company is put on notice, it may then sue the generic company. And if it does so, it obtains an automatic 30-month stay of generic approval by the FDA. The FTC's position is that by improperly listing patents in the Orange Book, brand companies are obtaining a 30-month stay of generic approval that it otherwise would not be able to do so. And therefore, according to the FTC, that is an unfair method of competition. So since issuing this FTC statement in 2023, the FTC has taken some actions. In November, it issued letters to 10 companies challenging that approximately 100 patents had been improperly listed in the Orange Book. The FTC claims they were improperly listed because these patents cover drug devices. And according to the FTC, only patents that cover the active ingredient in the product should be in the Orange Book. In other words, the FTC is taking a bright line without considering the rationale behind listing of the particular patent or the history of how the Orange Book has been handled. In response, some companies have delisted certain of their patents, others have not. Some companies have made public statements about their rationale, others have not. Likely, this issue will continue to percolate through the system in 2024 for two reasons. One, the FTC has not taken any enforcement actions yet, but it has stated that it reserves the right to do so. And the FTC is stated it is reviewing other patents. In addition, other areas of the government have also taken interest in this issue. For example, within the last 2 weeks, Senator Klobuchar issued follow-up letters to several of the same companies requesting that they go ahead and delist their patents. So we expect to see this to continue throughout the year. The other FTC initiative from 2023 that we think will continue into 2024 involves the FTC's challenge to conduct that allegedly increased healthcare costs by companies engaging in roll-ups or serial acquisitions of companies in the healthcare space. Specifically, in September 2023, the FTC sued U.S. Anesthesia Partners and the private equity company Welsh Carson that created it, and alleged that the companies engaged in a scheme to systematically buy up smaller anesthesia practices in Texas to create a monopoly, to create a dominant position in anesthesia in all the major cities in Texas, with one goal in mind: to raise prices. FTC also alleges that the defendants engaged in a price fixing and market allocation agreements as well. The defendants have challenged the FTC's case and brought a motion to dismiss, challenging both the legal theory and the FTC's jurisdiction to challenge consummated deals. This will continue into 2024. The FTC just recently filed its opposition to the motions to dismiss, and reply briefs are due next month. In addition, and as often happens, there has been follow-on class actions filed by several union welfare plans, claiming that the conduct of the defendants in this case has caused a higher healthcare costs for their members. Now I'm going to pass it to Lisa to discuss the new HSR rules and merger guidelines.
Thank you, Danielle. Before we get started, as a reminder, for those who require CLE credits, please click on the link shared in the chat feature. And the CLE code is Venable Antitrust 24. That's Venable, capital V, no space, Antitrust, capital A, no space, the number 24. So, turning to the proposed revisions to the pre-merger notification process. So, under the Hart-Scott-Rodino Act, parties to proposed transactions, such as mergers and joint ventures that meet certain filing thresholds, must submit what's called a pre-merger notification to the FTC and DOJ. The deals cannot be closed until certain specified waiting periods expire. So currently, this pre-notification process involves completing an HSR form, which is fairly straightforward and arguably not especially complicated, and producing a limited set of documents, so-called 4C and 4D documents, and some accounting data. But this past June, DOJ and the FTC proposed massive changes to the pre-merger notification rules. These changes would fundamentally alter the pre-merger review process. The rules significantly expand the scope of data, documents, and other information required for HSR filings, regardless of whether the transaction raises competitive issues. By the FTC's own estimate, these new rules could quadruple the time required to prepare an HSR filing. And I will tell you that some experts predict that that number of quadrupling is much too low. So when will these rules go into effect? Well, quite frankly, it's anybody's guess. It likely will be this year, but the comment period expired in September of 2023, and that was after a 30-day extension. The FTC and DOJ can finalize the rules either as is or make additional changes to them based on the comments that they received. There will also likely be legal challenges to these proposed rule changes. This all means that the actual date for effectiveness is uncertain, but what is certain is the company should be aware of these proposed revisions and plan for them. So let me give you some of the highlights of the proposed rules. Filing parties could be required to provide comprehensive narrative responses describing horizontal overlaps, horizontal and vertical supply relationships between the parties, potential labor market overlaps, and the rationale for the transaction, among other responses. Currently, there's just one short narrative portion of an HSR filing, and it's a transaction description. So the new rules could also require the production of very detailed information, including sales, customer contact information, licensing arrangements, non-competes and non-solicitation agreements regarding the products and services at issue, and much more. This requirement for comprehensive narrative responses moves the US towards the EU and China, where the pre-merger filings require such narratives. However, in these jurisdictions, there's a short form for transactions with no competitive effects. A short form is not part of the HSR overhaul. The proposed changes could also require the parties to identify all prior acquisitions, including non-reportable transactions in the past 10 years in any line of business where there's a potential competitive overlap. So think about that for a minute. The new rules could also require parties to produce drafts of items 4C and 4D documents, and those, as folks who do deals know, are documents that analyze the proposed transaction with respect to aspects of competition. And right now, only final versions must be produced. The proposed rules could require parties to submit a projected closing timeline and a diagram showing relationships between all entities and persons. And the new rules could require parties to disclose labor law violations by the parties in the past 5 years. So, as you may have surmised from this discussion, to describe these proposed changes as significant is perhaps an understatement. So, let's turn to a related topic, and that is the FTC and DOJ's revised merger guidelines. Today, Bloomberg reported that regulators in the US and Europe are increasingly cracking down on deal making. They were talking about big tech in particular, but I would tell you I think it's broader than that. And this is causing analysts to warn that large companies are going to have a hard time completing any major M&A activity in 2004. So this view may well reflect that a little over a month ago, the FTC and the DOJ jointly issued the final version of their 2023 merger guidelines. This followed a public comment period on an earlier draft that was released in July of 2023. These are an overhaul of the 2010 horizontal merger guidelines and the 2020 vertical merger guidelines. The new guidelines reflect the current DOJ and FTC's highly aggressive approach to merger enforcement. The guidelines are not binding on the federal courts, but they do reflect the policy of the FTC and the DOJ regarding the antitrust analysis that is applicable to proposed mergers. Some aspects of the guidelines reflect novel, untested agency theories, and it remains to be seen whether the courts will adopt them. In addition, if there's a change in administration, you could see a dialing back of these guidelines. So what are some of the notable changes? First of all, there are significant changes to the structural presumptions used to identify mergers that may be found to substantially lessen competition, the so-called Herfindahl-Hirschman Index, or HHI. Deals that result in a combined market share of over 30% and an increase in the HHI of 100 from pre-merger levels are presumptively illegal under the new merger guidelines. These guidelines also include an emphasis on vertical mergers and those that eliminate potential competition in concentrated markets. Earlier, Danielle talked about an FTC case in 2023 alleging that a private equity firm used a roll-up or serial acquisition strategy to monopolize anesthesia practices in Texas. That focus on private equity and serial acquisitions is also reflected in the new guidelines. As you'll see here, Guideline 7, it says the agencies may evaluate a series of acquisitions as part of an industry trend or evaluate the overall pattern or strategy of serial acquisitions by the acquiring firm collectively. You will hear next from Bill on enforcement trends in labor markets. That focus is also reflected in the new guidelines. They state the agencies will consider whether workers face a risk that the merger may substantially lessen competition for their labor. Where a merger between employers may substantially lessen competition for workers, that reduction in labor market competition may lower wages or slow wage growth, worsen benefits or working conditions, or result in other degradations of workplace quality. It's the guidelines at 10. So let me now turn this over to Bill, who will talk about developing areas of antitrust enforcement in the labor markets.
Thank you, Lisa. I'm now going to discuss a couple of major issues that should be a continued focus in 2024 with respect to labor markets, so-called employer no-poach agreements, and the FTC's rulemaking around employer non-compete agreements. Starting with the no-poach aspect of this, in recent years, DOJ has taken the position that naked no-poach agreements, including no-hire and non-solicitation agreements, and wage-fixing agreements between employers are violations of the antitrust laws subject to criminal penalties. Now, what do I mean by naked no-poach agreements? As alleged, these are agreements between employers, meaning between two different companies, that are not tied directly to any legitimate business dealing or transaction between the companies. They are standalone agreements between companies not to hire or solicit each other's employees or to agree on what they will pay each other's employees. These types of naked no-poach agreements differ from so-called ancillary agreements not to solicit or hire employees. For example, clauses not to hire or solicit that are included in a broader services agreement between two companies, or the sale of one company to another. If those clauses are reasonably necessary and limited, then they should be analyzed under the rule of reason and not subject to criminal prosecution. And as discussed before, that is where the pro-competitive benefits of the provision would be weighed against any anti-competitive effects under the complex balancing test. But with respect to naked no-poach agreements, courts have been open to DOJ's theory that these are per se illegal. And these types of per se agreements are the violations of the Sherman Act that the DOJ prosecutes criminally. These courts have been open to this type of theory at the motion to dismiss stage, allowing the DOJ to take these cases to trial, although trials have resulted in acquittals or dismissals. Despite these setbacks, DOJ has indicated they plan to continue enforcement efforts in this area. Assistant Attorney General Cantor has recently stated that DOJ is just as committed as ever to using our congressionally given authority to prosecute criminal violations of the Sherman Act in labor markets. And criminal actions are not the only risk in this area. Civil plaintiffs have also brought class action lawsuits alleging this same type of per se allegation with no poach agreements, many resulting in substantial settlements. As opposed to the no poach agreements just discussed that are entered into between two employers, there has also been action with respect to agreements that limit hiring or solicitation in agreements that are between an employer and its employees, often in employment agreements themselves. In January of 2023, the FTC proposed a rule that would, with certain limited exceptions, ban all employee non-compete clauses. A non-compete clause is defined in the proposed rule as one that prevents the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. The rule would apply retroactively and require rescission with notification to employees with covered non-compete clauses. The rule exempts franchisees, but not their individual workers, or non-compete clauses in the sale of a business that are applicable to a substantial owner of, or substantial member, or substantial partner in the sold business. The non-compete clause ban has only been noticed as a proposed rule, and the most recent reporting is that the FTC is not expected to enact the rule until April of this year. The proposed rule has a 180-day compliance window. So based on this schedule and reporting, compliance could be required as early as October of 2024. Moreover, certain states already include restrictions or prohibitions on non-compete clauses with employees. Most notably, California's complete ban carries criminal penalties and has a deadline of February 14th, 2024 to notify employees that any existing non-compete clauses are void. We will now move into some general practical advice in navigating these types of waters. Lisa, will you please start us off?
I will indeed. And also, we are opening up the question functionality on the webinar. So if you have questions, please feel free to submit them pursuant to the question widget. So turning to some practical advice, much of antitrust enforcement and private lawsuits focus on whether competitors have reached an agreement on an aspect of competition, such as price or output. An agreement is most often proven through circumstantial evidence. That is, evidence from which an agreement can be inferred as opposed to direct evidence. And these allegations often include so-called opportunities to collude. So one important example of an opportunity to collude would be meetings with competitors. Meetings between competitors must have a legitimate business purpose. So start with the question, why are we meeting? And is the meeting necessary? Assuming that you answer yes, that the meeting is necessary, and two, it has a legitimate business purpose, then certain precautions should be taken to help minimize antitrust risk. For example, consult with your antitrust counsel prior to the meeting. Get some guardrails for the meeting from your antitrust counsel. Second, have an agenda circulated in advance and stick to the agenda. Everybody knows specifically what is to be discussed and what is not to be discussed. And then consider having minutes reflecting actions that were specifically taken at the meeting. Speaking of what should not be discussed, do not discuss prices, bids, or fees, or features that can affect prices or output. Things like discounts, costs, production, or margins. Immediately stop any such discussions of the above topics or leave the meeting, whether formal or informal, where you believe improper subjects are being discussed or there's a suggestion to discuss improper topics. Make your exit memorable. Consider spilling a Diet Coke. Make sure people know that you left that meeting and refuse to engage in that topic. And notify your antitrust counsel or your in-house counsel as soon as possible so that he or she can respond as appropriate. Social functions among competitors are especially ripe for allegations of opportunities to collude. There's sometimes alcohol involved. People are more relaxed. There can be multi-day events, so a potential for, quote, opportunities to collude. It's important to remember that just because you're off the clock and away from the office does not mean that the antitrust laws do not apply. Again, if competitors seek to discuss an improper subject during a social function, stop the conversation, walk away, make your departure notable, and notify your counsel as soon as possible. So with that, let me pass it over to Danielle, who will give some practical advice regarding writings.
Thanks, Lisa. So as we talked about earlier, antitrust cases involve extensive discovery. And this is because generally in antitrust cases, we're trying to look at, was there an agreement between the defendants? Was there an agreement, for example, to fix prices, to suppress supply? And what happens in discovery? You'll be asked for reams and reams of data, documents, emails, memos, increasingly text messages, and social media as well. These all will be forms of discovery that the private plaintiffs or the government enforcers will look at to try to discern what was really happening at the time of the alleged agreement. What were the communications? What were people saying about the meetings or their communications and what they were trying to do? So it's really important as you go through your general business day and think about your documents and instruct others in your company to think about what you write. Because the reality is anything you write can and will be taken out of context and will be viewed in the worst possible light if you and your company are named as defendants in an antitrust case. What's some important things to remember? This is real. This comes from real life experience and real life litigation. For example, in the FTC case versus Facebook, one of the prime allegations focused on an email that Mark Zuckerberg wrote, where he said, it's better to buy than compete. Those types of emails are the types of things that government enforcers and private plaintiffs like to find and put right in the heart of their complaint. So it's important that as you write in your business days, that you think before you write. You write in terms of actual facts without suggestions of power words, things like jokes do not read well 5 years down the road. It's important to think about, as a general rule of thumb, I have a couple of teenagers and I tell them for social media, the grandma rule. I say, is this something that you want to have to explain to grandma later, what you meant and what you were doing? And the same goes for any kind of emails and writings that you're doing. Think about it this way. Is this something that I really want to write that I would have to explain to the DOJ or maybe to a judge or a jury down the line, and why what I wrote wasn't real, I was just joking, and have to explain why their interpretation and saying what I said and taking it out of context is not what I meant? If the answer is that's not what I want to do, think about what you wrote and keep to the facts. The same rule applies when you're in text messages and messaging apps. And increasingly, that's how we all communicate, both for business and personal use. And accordingly, more and more discovery in antitrust cases is focused on these text messages and messaging apps. There are subpoenas, not just to individuals or companies for phone records, but also to the phone companies themselves to get the records of who was calling who was texting who was talking to who on social media platforms. And the plaintiffs or the government enforcers will try to connect the dots and try to figure out what communications happened and then what happened next. For example, they will try to allege that there were communications between two competitors, and then those two competitors both increased their prices. So all of the same rules will apply to text messaging as to any kind of emails or other memos you would write. And you don't have to take my word to believe it. Some real life examples, for example, in the generic drug price fixing case, in which we have seen hundreds of millions of dollars in fines that have been paid, the indictments and the complaints themselves cite over 300 calls and text messages between alleged competitors. Similarly, in the tuna antitrust case, in which the CEO was sentenced to jail, one of the prime pieces of evidence used in the case involved a text message between the executive and the CEO. The executive texted the CEO, "The industry is listening to me." And the CEO's response was, "Who's listening? If it's illegal, don't tell me." And of course, that was taken in the light and used against the CEO because the response, the government claimed, should have been, "If it's illegal, don't do it," not "don't tell me." So again, as you go through using text messaging and messaging apps in your business, think before you write and recall that anything you say can and will be viewed in the worst possible light if you wind up as a defendant in an antitrust case. I'm going to pass it to Bill to talk about responding to subpoenas.
Thank you, Danielle. Here's some quick practical steps to take if you do receive a subpoena, civil investigative demand, or other type of request from the DOJ, FTC, or a state attorney general. And really, this practical advice applies to all types of requests from government entities, not just those focused on antitrust issues. The first step is you should immediately contact counsel before responding to or reaching out to the issuing agency. Counsel will be able to assist you in understanding the type of request and your corresponding rights and obligations, as well as a strategy for responding to it. Second, you should work with counsel to understand the government's power. While broad, it is not limitless. Third, communicate through counsel with the issuing agencies. Oftentimes, these subpoenas are intentionally written to cover almost the entire earth of a company's documents. And they may appear on their face, and they are impossibly broad to comply with. But counsel often negotiate the scope of the response with the issuing agency to make it manageable for the clients. Finally, you should preserve all relevant information and implement an effective document and data collection plan. I do think we might have time for a few questions. But before I do, we did have a request to repeat the CLE code if we could. So I will repeat that now. It is Venable, capital V, Venable, no space, Antitrust, capital A, no space, 24. Venable Antitrust 24. Lisa?
Yes, we got a question that asked, it's no longer here, but whether or not the antitrust laws are enforced against associations, and in particular not-for-profits. And the answer is yes. The FTC has a history of enforcement actions against associations and continues to pursue enforcement efforts in this area. In the case that Danielle mentioned, it was private action against the National Association of Realtors. There was a jury instruction on associations, and to quote it, it's instruction number 29, an association is capable of committing violations of antitrust laws. Quote, if a trade association exchanges with its members confidential, competitively sensitive information, such as current or future prices or current or future output information, that is evidence which you, the jury, may consider, along with other evidence, in deciding whether the association is in violation of the Sherman Act. So the short answer to your question is that the antitrust laws are applicable to associations and nonprofits, and they are in fact enforced against them. Let's see, do we have another question? That one. Any other questions? All right, well, we should thank you again for joining us today. It's been our pleasure to talk with you. We will say that if your company or association would like an in-person antitrust compliance program that's tailored specifically to your needs and your legal issues and your organizational structure, please feel free to give us a shout. We would be happy to meet with you. Also, Bill just went over the CLE code, but as a reminder, click on the link. If you need CLE credits, click on the link shared in the chat function. And again, as he said, the code is Venable Antitrust 24, no spaces, in capital V and capital A and the number 24. This form, along with a copy of the slide deck, will be emailed to all attendees next week. So it looks like we are finishing up about 10 minutes early, so you get 10 minutes of your day back. So thank you to everybody and have a lovely day.
Thank you all.
Thank you.